Good evening, ladies and gentlemen. The time is now 6 p.m. This meeting will take place. We'll start with the roll call.
All right, Sonny Bernos.
Here.
Fran. Here. Linda.
Here.
Evan.
Here.
And Sylvester.
Here.
At this time, could everyone please stand and we'll do the Pledge of Allegiance, and then we'll take 1 moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Has everyone gone over the minutes?
Yes.
Okay, do I have a motion for approval as they stand?
I'll make a motion to approve as they stand.
Do I have a second?
I'll second.
All in favor?
Aye.
Aye.
Aye. Motion passed. Okay. Good evening, ladies and gentlemen. I'd like to welcome you to the July 21st, 2025 City of Clermont Code Enforcement Board meeting. Before we begin, I would like to advise everyone that the procedures that govern appearances before this board. This meeting is open to the public under Florida's Government in the Sunshine Law. The Code Enforcement Board is acting in a quasi-judicial capacity when considering individual cases. However, every effort will be made to hear all persons having relevant evidence or argument to offer in accordance with rules for such proceedings. We ask that each person who speaks before the Code Enforcement Board sign the sign-in sheet located on the table up front. After the opening remarks, all those who intend to speak today will be sworn in or affirmed. When asked if a respondent is present for your case, please come up to the podium. All proceedings before this board are electronically recorded. Please speak directly into the microphone at the podium and state your name and address clearly for the record. Additionally, please limit your comments to only information relating to the case being presented. The City of Clermont has the burden of proving a violation exists. The city presents their case and then the respondent presents theirs. Once all cases where respondents are present have been heard, the board will then hear the remaining cases. Each party may question witnesses offered on behalf of the other party. Additionally, the board members and their attorney may question those appearing before the board. This board will then make its decision based upon the evidence and testimony presented by both parties. The board's role is to determine if a violation exists and, if so, in most cases, set a date for the violation to be corrected and set a fine if compliance is not met. It is not the board's role to advise you of a specific method or act that you can take to come into compliance. The Code Enforcement Board is appointed by the City of Clermont to review review alleged violations of City of Clermont Code Enforcement ordinance fairly and objectively. Its members are volunteer and not employees of the city. The board's authority is limited to determining if a violation of the code exists. It does not have the authority to change the code or ordinance. Although you may have evidence, argument, or circumstances that could justify being excused from compliance with the applicable code, you are advised that this board does not have the authority to grant you an excuse. Such an excuse is commonly referred to as a variance or exemption, and may be granted through other procedures such as applications to the city, but not by the Code Enforcement Board. To avoid interference with cases being presented to this board, all cell phones are to be turned off or silenced while in chambers. Thank you.
Okay, if you are here for a case and you intend to testify, now is the time where I'll place everyone under oath, including the city's officers who are here to present testimony. So if you're able to, I'd ask you to please stand and raise your right hand if you're going to provide testimony. You can stay in your seat if you're not able to stand. Do you swear or affirm the testimony you're about to give? Okay. Good. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated.
My name is Avery Dyan. I'm the Assistant City Attorney, and I'm just going to go over the agenda for tonight. First, we'll start with unfinished business. We have one item that's case C24040038, John and Cindy Zentmeyer, 1050 West Magnolia Street. Then we'll move to new business. We'll start with item 3, case number C25060009, Southern Villas Lot Owners Association, Inc., vacant lot on Villa Court. We will move on to item 5, which is case number C24100015, Euclides D. Corona Gutierrez at 3262 Hanging Tide Street. And then we will move to item 2, which is case number C25060012, Edward Emmerich III at Cluster Oak Drive. And finally, item 8, which is case number C25020006, which is Reliant Flips LLC, 550 Distant Avenue. Thank you.
Good evening, Code Enforcement Board. Joshua Cortez for the City of Clermont. This is case number C2404-0038, Zentmeyer John E. and Cindy Jean at 1050 West Magnolia Street. The code sections cited are sections 307.1 General, 605.1 Installation, 308.1 Accumulation of rubbish or garbage, City Code Section 125.522 Building Permit Required, International Property Maintenance Code Section 112.2 Temporary Safeguards, 304.1 General, 304.1.1 Unsafe Conditions, 304.2 Protective Treatment, and 304.6 Exterior Walls. This is a copy of the finding of facts and order from the Code Enforcement Board dated September 16th, 2024. This is an order from the Code Enforcement Board on May 19th, 2025 for an order granting continuance. This is a screenshot from Property Appraiser showing the property's location. This was the notice of hearing sent out by the city's legal department. A picture taken when the case was first opened. A picture taken today. So the Code Enforcement Board held a hearing on this case September 16th, 2024. The property came into compliance on July 1st, 2025. The days in violation were 257. The daily fine ordered was $150 per day. The fine assessed is $38,550. I have nothing further if you have any questions for me, and I believe the respondent is here.
Sir, would you just tell them what your city's requesting?
The city's request is a motion to impose the fine. To impose the fine.
And to record the lien, right?
No, sir.
You don't want to record the lien, okay.
Question for you, Josh. I see you say property in compliance on July 1st, but your picture from today still showed, it looked like, can you go back to that? I thought our issue was the handrail up on the second floor balcony.
Yes, sir. So they obtained
So
a
then the
permit.
property is still not in compliance, but they are in the process. Do they have their permit in?
So compliance in this case was permits issued, not work completed. So in this case, they are in compliance.
Okay.
Do you want to come on up, sir?
I'm John Zentmeyer, 1050 West Magnolia Street here in Clermont.
Yes, I'm just trying to understand why this took so long.
Well, when I came, when they started the fine, or when I guess the first meeting that I was here, we had secured everything. We had hired an engineer, but we could not move forward until the engineering was done. As soon as the day the engineering was done, I believe within a day, we had a permit, and that was the 1st of July.
I
So
see.
We went out to probably 4 different engineering firms and only found one that would accept us and take the work. The problem was we were in line, and we were a teeny tiny little job when they had lots bigger jobs. So last meeting I was here, I brought my engineer, and he basically testified that I couldn't do anything until I got a permit, and I couldn't get a permit until I got the engineering done. And the moment the engineering was done, we got the permit. So we're ready to finish everything up now.
Okay,
Could you go back to the recommendation sheet? So just to be clear for the board, you're asking for them to impose a total fine in the amount of $38,550 for the 257 days the property was out of compliance.
That is correct.
I've been in that house for 40 years. I've paid taxes for 40 years. I'm a good citizen here in Clermont, active in the communities, and I'd like for you guys to waive the fine. There was really nothing I could do because I was waiting for engineering. I could not apply for a permit one day sooner than I did. And so I just, and which I actually made that comment that I was beholden to the engineering timelines, you know, when that clock started. And so that was kind of a known thing, it was going to be a while. And so I was stuck.
you can put in a request to reduce the fine.
Okay.
That, I don't know if you were aware of that?
Well, I'm aware of that. Is that another meeting that I go to? That's
Yes,
what I
that you have,
know that it was for this meeting, so.
No,
Okay.
it would be a separate meeting,
That's-
separate
yes.
application.
Yes.
So I'm just requesting tonight, and I don't know if it can be done, Josh wasn't sure, but I'd like to get it waived and let me finish my work and be done with it.
My best suggestion would be to put a request in for reduction of fine, because then we can work with that.
Okay, I'll do that.
But that's the limitations of what we can do.
Okay.
I think,
I'll put that in.
I think we'd like to see that once you have all of your work complete, and then you come in and show that everything is done.
Okay,
Because right now you just have the permit. So,
That's correct.
so you're technically still in violation for the unsafe condition. So
I
once,
don't think I've secured the door, it's bolted.
Okay.
It's blocked with wood, it can't be opened, so it's not unsafe anymore.
Gotcha.
And that was done when this started, that was already done
Yeah.
before that. We just can't build a railing until we have a permit.
right,
Now we got the permit, we can build everything, so.
yeah, yeah,
But
I
I'll
would,
be glad to do that.
yeah, I think that's probably be the best.
Come back, okay?
Say everything's done, and then we can
Sure.
have that discussion at that time.
Okay, I'll be glad to do that. And how do I put that request in, or is that?
You would have to go to the code enforcement, and they will give you the documents that you need to fill out to
Okay.
request a reduction in fine.
Okay, I'll be glad to do that. Thank you.
Mr. Zentmeyer, I just have one question before you leave. Why did this require an engineering consultant instead of just a general contractor to do the work? I mean, we have plenty.
Whether it was a general contractor or myself, it still had to go through engineering because of the, all the wind loading, all the things that have changed. I mean, we basically repaired water damage that had caused a main beam to fail on the balcony. We didn't build a new balcony, we're just repairing it.
Oh.
And, but there's a bunch of, it's way different today than when it was built, I don't know, 30 years ago, 25 years ago. So, I guess that's why, I mean, city requested that it get engineering be done.
Okay.
Yeah, and I had them come out and look at it, and they said, yeah, you gotta get an engineer, so,
Thank you.
okay? Thank you. Thanks,
I
John.
have a question for you, Attorney Brackens.
Okay, yeah, because the hearing's not over.
Yeah. So
Am I done?
No, not yet.
is the process to impose the fine?
Yeah,
and then come
that's
back
what
later?
the city's at, so typically, at the board sets an order, sets a date for the, property to come into compliance. If compliance is not met within that date, then there's a separate order imposing the fine. What they're asking you to do here is go ahead and impose the fine amount now that it's come into compliance in the amount of $38,550. That's the action that's before you, is to impose the fine amount.
But even though it will be imposed, you can ask for a reduction. And
Right.
this is where we're trying to,
Dot the i's and cross the
And-
t's?
yes.
Yeah, until the board imposes a fine amount, he can't ask for a reduction, so
Oh,
that's,
but-
it's,
Oh,
Yeah.
okay.
Yeah.
Okay. Unless you guys just wanna waive it tonight, we can get the whole thing, so. But I'll be glad to come back. I have no problem doing that, so if that's the way you wanna do it, I have no problem finishing it and coming back. I'm ready to go now, so finally.
Perfect.
What's the appropriate motion?
the motion would be to, based on the testimony and evidence, to impose the fine of $38,550.
As far as the motions that we have, or orders?
So the closest one to it is number 13, but the city's not asking for a lien. So you would just, on number 13, you would say, based on the testimony presented in the case, cite the case number. I move to find the respondent did not come into compliance by the date required in this board's order. I move to order that a fine in the amount of $38,550 be imposed on the property, consistent with the board's prior order.
Do I have a motion?
I'm going to try. on
You
this
could say so moved if you really needed to.
one. So moved.
I'll second that.
All in favor?
Aye.
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 You have what you need for the order. Now we're going to number 3 on the docket, is that right?
Yes, sir. Okay, this is item 3, case number C2506-0009, Southern Villas Lot Owners Association, Inc., at Villa Court. This is a repeat violation. The code sections cited are Section 1853, prohibited items, conditions, or actions constituting nuisances. 1854, creation or maintenance of a nuisance by property owner declared unlawful. And Section 3024 of the International Property Maintenance Code, weeds. This is a screenshot from Lake County Property Appraiser showing the property's location. This is a case summary. The violation hearing notice were posted on the property June 17th. The compliance date was immediate. The results of the inspection as of today is that the property is in compliance. This is a copy of the finding of facts, conclusion of law and order from the Code Enforcement Board held on September 16th, 2024, finding the respondent in violations of the section stated therein. This is a copy of the notice of hearing and repeat violation notice that went out, along with the affidavit of posting. This is a photograph of the property taken on 6/17/25. Another photograph. Another photograph. Photo taken on 6/23. Photo taken on 6/26. 6/30. Property is in compliance. And then again, 7/21, property remains in compliance. The staff recommendation to the Code Enforcement Board is to find the respondent was in violations of section stated. Further order that a daily fine in the amount of $500 shall be imposed beginning on June 17th, 2025, continuing to and including June 29th, 2025, for a total runtime of 13 days and a total fine amount of $6,500. I have nothing further. If you have any questions for me, and the respondent is here.
Joshua, could you go back a couple of slides to the date schedule where it came into compliance? Just, I'll tell you when to stop. There, thank you.
And just to clarify, that slide right there is as of today. So the property was in compliance on the 30th. That was when I performed my inspection and found it to be in compliance.
So Josh, when you pulled up that full aerial on the parcel there, it extended all the way back. You don't need to go back to it. So really, they're only responsible for maintaining that area along the right of way.
Correct.
Okay.
Is there something you'd like to say to the board?
Yes, actually, I have a couple questions, but I understand now that I need to go back to the inspector, and so I'll ask him on that. At this time, we were going through changes, one with our landscape company, the crews, and with the manager on site, has left our company, and so I've been here today. And so, yes, we are working to be in compliance, and we ask for, and this has obviously happened in the past when we go through landscape issues or hurricane issues. And so we're still, I know you don't want to hear it, we should know after 20 years, but we're working on coming into compliance and staying in compliance because this is embarrassing to see the grass 2 feet high. So we're working on it. It has been in compliance for the last 2 weeks.
And at this time, you have someone reliable that you can depend on who's going to be doing a...
Let's hope so, as dependable as they can be.
I understand.
But he's getting ready to, I think we'll be changing contracts again to get, and to stay in compliance. We're working on it, yes, ma'am.
Does anyone else have any questions?
All right. So in the event the board wishes to adopt the city's recommendation, it would be number 7 on your motion sheet. A couple of the items in there of note is that in the first paragraph, the date of the violation, I believe, was June 17th, 2025,
Yes.
first date, and that it was corrected
29th?
June 30th, I believe, but June 29th is fine. That the repeat is a violation of the board's September 16th, 2024 order. Then, based on the city's recommendation, they want the fine to accrue from the June 17th through the 29th for a total of $6,500. Is that correct?
Correct.
All right. So this proposed motion gives you a lot of different options. The fourth paragraph, which begins with if the respondent does not comply, that paragraph does not need to be read. It's not consistent with the city's recommendation. The only additional paragraph that would need to be read is the one just following it that says, due to the repeat and fleeting nature of the violations and the number of times it was observed before corrected. And that's it.
Do I have a motion?
I'll go ahead and make the motion. Based on the testimony and evidence presented in CEB case C2506-0009, I move to find that the respondent was in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in matter on June 17th, 2025. I further move to find that this violation constitutes a repeat or recurring violation of the board's prior order dated September 16th, 2024. I move to find that the respondent on or before the date of June 29, 2025 did correct the violation. I move to order the respondent refrain from repeating the violation. That I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. Due to the repeat and fleeting nature of the violations and the number of times it was observed before corrected, I further move to impose a one-time fine in the amount of $6,500.
I'll second that.
All in favor?
Aye.
Aye.
Understand, as I said to the other gentleman, you can request, and we can go from there.
So we're going to go backwards to item 2 as the respondent is present.
I don't know if he was sworn.
Okay.
Gotcha.
Item 2, case number 2506-0012, Emmerich Edward E. III.
All right, before you begin, because they just came in, let me swear in any of their witnesses. Okay. Well, you can raise your right hand that you're writing with. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Item number 2, case number C2506-0012, Emmerich Edward E. III, Cluster Oak Drive. This is a repeat violation. The city code sections cited are 1853, prohibited items, conditions, or actions constituting nuisances. 1854, creation or maintenance of nuisance by property owner declared unlawful. City Code Section 125-522, General Development Conditions, and Section 3024 of the International Property Maintenance Code, weeds. This is a screenshot from Property Appraiser showing the property's location. This is a case summary. This was a via citizen complaint. The violation and hearing notice were posted on June 24th, 2025. The compliance date was immediate. The result of the inspection today is that the property is in compliance. This is a finding of fact conclusion of law and order dated July 30th, 2024. This is a repeat finding of fact dated November 20th, 2024. This is a notice of hearing, violation notice, and affidavit of posting. A photograph of the property. Photograph taken on July 2nd. Photograph taken on the 7th. Again on the 21st. The staff recommendation to the Code Enforcement Board is to find the respondent was in violations of section stated. Further order that a daily fine in the amount of $500 shall be imposed beginning on June 24th, 2025, and continuing for 9 days, ending on July 2nd, 2025, for a total fine assessed of $4,500. I have nothing further if you have any questions for me, and the respondent is here.
Is the property in compliance now?
Yes.
Okay, good. Any other questions? Is there something you'd like to tell us?
I'm not sure of the process here, so I just want to follow whatever that process is. Do we ask questions of this person, or
You can ask questions of the officer. Yes, sir.
I can ask questions of the officer? Between the date of June 24th and July 2nd, how many times did you go to the property?
Between June 24th and between the 24th and July 2nd.
Yes, sir.
Take a look here. So here I have one inspection, but I believe it was closer to 3, but I don't have those photographs on here.
Okay. So we go straight from the 24th to the 2nd, right? And that would indicate that the first picture you have here is from the 2nd after the alleged violation on the 24th, right?
Can you ask that again?
The first picture you have in the evidence that you brought today is from the 2nd. Is that accurate?
Let's see. So the first photograph was taken on the 24th, followed by an inspection on the 2nd, followed by an inspection on the 7th that I have listed here. There may be one more in between those photographs, but I can't say for certain as I haven't included them.
But you found that on the 2nd, the property was in compliance, correct? Which is why you're recommending to the board the violation be from the 24th to the 2nd.
Yeah, so once I went out there on the 7th and observed that it was in compliance, I backdated it to the date of my last inspection where it was found to be not in compliance, which I have as the 2nd there.
So you have the 2nd as non-compliance. Can you pull the picture back up for the 2nd again? Is this the section that you're saying is non-compliance, or is it more than just this one picture?
So I have a few photographs. They may not be included on here, but that is one of the primary sections of property that I found to be not in compliance.
Okay, and what is not in compliance about this picture that we're looking at right now?
Overgrowth of grass and weeds exceeding 18 inches.
Okay, and of the things in that picture there, what are we seeing that is a weed or grass rather than being an ornamental bush, a flower, something else?
Yeah, so I would say that all of the vegetation pretty much except for trees and things like that are going to be grass and weeds and not ornamental flowers and so on.
And did you do some variation of experiment or something like that to determine what the nature of these bushes or shrubs or whatever that might be is?
No, I didn't perform any experiments.
Okay. Now, between June 24th and July 2nd, did you go out on the property at all?
Between the 24th and the 2nd, It's possible, but I'm not certain at this time.
Now, in the earlier report, you seemed to indicate that the, coming into compliance, like, it said immediate. Why did you put that there?
This compliance was immediate as this is a repeat violation.
So because there was a prior violation found, you found that this new violation was immediately in compliance? I'm confused.
So I may have misheard you, but are you asking, was the property immediately in compliance?
Well, you put on a form in there, right, that compliance was immediate?
Correct, yeah. So when it says compliance immediate, that is the time frame given by the officer to the respondent.
So there wasn't a 10-day period to correct the violation?
No.
Okay. Do you know if the city manager asked the clerk to send a letter giving the 10 days notice that's required?
So it sounds like you may be referencing other sections of our code, but as far as immediate compliance goes, that is in line with Florida Statute 162 for repeat violations, where no compliance, no reasonable amount of time for compliance needs to be given.
Okay. What I'm really trying to do is, I don't have more questions.
I do have something. I think we've missed this the last two. Can you state your name and address for the record?
Edward Emmer, 4th. My address is 381 Breckenridge Lane, Clermont.
Thank you.
Well, first, I just want to clarify, are you on behalf of respondent, or, okay, are you an attorney? Okay. And the respondent is with you today?
No.
No, okay. Were you hired by the respondent?
Technically, yes, this is our dad.
Okay. Do you have any documentation that you can speak for him today? Well, I just want to know if, do you plan to give testimony, either of you?
No, that's really it.
Okay, okay. I just have a couple questions for Josh. Is this the first code compliance case regarding weeds on this property?
No.
Okay, how many other cases have there been on this property?
At least 3, but probably closer to 6.
Okay, that's all I have right now.
Counsel? No. The gentleman here, not you. Him. Did you had an opportunity to question the officer. Do you want to make any argument before the board?
Sure. So it's my understanding that you guys have various factors that you need to consider when you're considering how you're going to rule with respect to this. And so the most important aspect of this for us is that this is a problem that has been fixed, and it's the most important problem for the city. And so during this process, and I believe in prior hearings, it's been brought to code enforcement's attention that this was something we did not understand to be a violation from our communications with the clerk. I think that's in some of the, or from the code enforcement officers that have come out. It's something that my client has taken the time to immediately come into compliance with. They have property management company, well, not property management company, but a landscaping company that comes out there frequently. And this is something anytime they receive any variation of notice of, it's being taken care of. In addition to that, it's our understanding this is being reported by the same person. I'm not sure why that is happening, but we have received information from them. We're trying to avoid this. The other argument that's a part of this is if you look at these pictures, you'll see that all the grass is being cut. What we have is some of these target areas. Now, my understanding is that the property is now come in compliance because there's been some extra time and effort put into this to make sure that the areas that have been a problem in the past will not be a problem in the future with respect to, and as you can see in all of the photographs that have been shown before you, all the grass is low, and then we have these, I'm not sure if it's a bush or if it's an ornamental plant or what it is, but these other types of vegetation, which are clearly different from the grass, are the issues that appear to be the problem. Those things have been taken care of in the pictures that we're now seeing to be in compliance. things that were a problem are a limited portion of the property. You know, some of the pictures that are taken like this one is kind of a close-up of one section, but some of the pictures that we saw today, when it's backed out, you recognize this is a very small part of the problem. Well, not part of the problem, part of the property. And so our position is the level of violation or the severity of the violation is somewhat minimal. The other issue that we have is the property owner clearly took efforts to come in compliance between 6/24 and 7/2. Because on 6/24, we see pictures of property looking like one thing, and then on 7/2, we see pictures of the property looking different. Now on 7/7 and 7/17, when the property owner realized there's more problems, those problems were taken care of. It's our understanding that this property is going to be, it's gonna have any grass on it whatsoever for about 5 more weeks. And so this shouldn't be a problem really ever again. The property's being developed, that is part of this. I don't want to come before you guys and argue technicalities or put my lawyer hat on too much or anything like that, but there are some problems with whether or not these things are a violation, the angle of it. There are several other properties that are similarly situated to ours that have, well, to this property, that have worse issues associated with it. And it's difficult to come here, have lived here for 30 years, drive by 6 other properties that are much worse, and somebody decides they want to target, you know, this property for whatever reason. And we've now been back here several times when the property literally across the street from this lot has higher grass, and they're not any of these meetings with us. The properties up and down 27 had more significant violations, and yet we're here today. I don't know that that's one of the factors you guys consider, but what I would like you to consider is that, you know, we've taken the time to come here today. We have taken the time to try and fix this issue on multiple occasions, and so we would ask, and also we have an issue with the time frame of the violation, and so we would ask that at the very least we limit that time frame, because it was something that was obviously handled within this within the time frame of 6/4 and 7/2, rather than for the entire time frame. Anything else?
Just to keep it as simple as possible, so.
Can you also state your name for the record?
Clayton Emmerich, my address is 1067 Calico Point Circle, Groveland.
Okay, before you start, just want you, so he is an attorney, he's representing the respondent. Are you?
Yeah, I'm an attorney.
Okay, all right, so you're both representing the respondent? Okay. I didn't want to turn you into a witness, they could then cross-examine you. So.
I just want to say like exactly what happened as simply as possible. So we found out, we hired previously we came here and we had a violation, so we hired a landscaping company. They come every Thursday. As soon as we found out about the violation, we contacted the landscaping company. We told them, hey, there's a problem, we need you to cut this. We thought it was the other side of the sidewalk. So I told the landscaping person to go out and cut specifically the opposite side of the sidewalk. But then it turned out that wasn't correct. What we thought is that the areas around the trees like this, and there's kind of like a tree line, and then there's bushes under it. We didn't think that was in violation because it was up against the trees. That's really the only reason. We didn't tell them specifically to weed whack that area. But we came in compliance as soon as we possibly could. We had no intention on being here. We don't want to be here. Things like that.
The city of Clermont.
Yes, I just wanted to state, to the extent that either of these individuals gave testimony, it's not on behalf of respondent. That just sounded like testimony, not representation. And just a member of the public.
No, I understand. My understanding is they're both representing that they're attorneys for the respondent, and they're making argument on the respondent's behalf.
To the extent it's argument, yes, but not testimony.
Right.
Correct.
They're
Yes,
not
yes, yes.
And if they were testifying, you'd absolutely have the right to cross-examine them.
Yes, okay. Yes, just a couple questions. Do you know when your father was first informed of the violation?
Well, that's part of the issue with respect to the 10-day notice that was brought up originally, is I don't think he did get notice until it was posted on the property. And
Is-
then he has to drop by there.
It was posted? Is that, the city posted it? Okay, let me just help everybody and save some time. Chapter 162.06 Florida statutes. If a repeat violation is found, the code inspector shall notify the violator. They can do it by posting the property, but is not required to give the violator a reasonable time to correct the violation. The code inspector, upon notifying the violator, posting the repeat violation, shall notify an enforcement board and request a hearing. Code enforcement board through its staff shall schedule a hearing and shall provide notice pursuant to the statute. So, to the extent that assists anybody, there you go.
Thank you. I'm just going to call Evie Wallace to give additional testimony.
Good evening, Code Board members and respondent counsel. Just to give you a little bit of background, I've been also involved with Officer Cortez since the very beginning, and this particular case, weeks before the complainant called, I traveled that area. I mean, I live here, I work here. I saw that through my training experience, it appeared to be over 18 inches. Your father, the mayor, myself, we went on an on-site visit last year, clearly went through the whole property, what needs to be done, what is required of the section to be in compliance. He understood having the property is under an acre, it has to be under 18 inches, no questions about it. He understood. I actually called him this third case. You know, Mr. Emmerich, just heads up, this is a courtesy call, which I don't have to do, but in my travels, it appears that you might be in violation just in case we get a call. Sure enough, I think it was a week or two later, the complainant did call. So we were trying to make efforts, you know, which we don't have to do, to try to, you know, get information, put it out there. I'm not sure what happened in between that, but once we get a complaint, we have to, by, you know, the city ordinance, our code, our policy, to move forward with that complaint. Therefore, this case was created. Just wanted to give you some information for this particular case. Thank you.
Any further questions?
I don't have any questions for Ms. Wallace. Thank you.
And the city recommendation?
The staff recommendation is what you see on the slide, but I can just go over it real quick again. The staff recommendation is to fine the respondent in violations of section stated. Further order that a daily fine in the amount of $500 shall be imposed beginning on June 24th, 2025 and continuing for 9 days ending on July 2nd, 2025 for a total fine assessed of $4,500.
Question for the officer. The board's prior orders were on July 30th, 2024 and November 20th, 2024.
Correct. So yeah, so the first time that this respondent was here before the Code Enforcement Board was July 30th, 2024, and then again November 20th, 2024.
Okay, November 20th. Can you go back to the July order real quick? July 29th, not the 30th.
Okay,
like
correction. Yeah, I'm sorry. So the 30th date was when that was actually sent out. The Code Enforcement Board was held on the July 15th. So yeah, correction there.
And the order was signed on the 29th. Okay.
On the 30th. On the 30th. Signed and sent on the 30th. Code Enforcement Board for that case, July 15th. And then
The chair signed it on July 29th. Do you agree?
yes, I do agree.
And that, okay, thank you.
Could you go back to the photos once again and give me a slow look? Thank you.
Can I get a motion?
Council, this is number 7, correct?
It would be the only, with the same, similar to the last one, the only thing I would add is it's not a one-time fine. If you were to adopt the city's recommendation, it would be the fine $500 a day from June 24th through July 2nd. Of course, the amount of the fine is in your discretion.
Understood, thank you.
And I'm sorry, I didn't, so just to repeat it, because my mic wasn't on. The second part of number 7, the amount of the fine, it's not a one-time fine if you adopt the city's recommendation. It's $500 a day from June 24th to July 2nd. Of course, the amount of the daily fine is in your discretion.
Thank you. I'd like to go ahead and make a motion. Based on the testimony and evidence presented in case CEB 2405-003, I move to find that the respondent was in violation of the City of Clermont's Code of Ordinance as listed in the notice of violation filed in the matter on June 24th, 2025. I further move to find that the violation constitutes a repeat or recurring violation of the board's prior order dated November 20th, 2024. I move to find that the respondent did correct the violation, and I move to order that the respondent refrain from repeating the violation. That I have considered the gravity of the violation and any action by the violator to correct the violation and any previous violations by the violator. Due to the repeat and fleeting nature of the violation and the number of times it was observed before corrected, I further move to impose a $500 a day fine beginning June 24th, 2025 through July 2nd, 2025, constituting 9 days for a total fine amount in fine amount in the amount of $4,500.
But before there's a second, I believe you read the case number incorrectly. So if you would accept a friendly amendment just for the case number.
Case number 24.
No. C. No.
Sorry, case CEB, correct, 24.
25.
It's on your screen.
2-5.
Oh, I'm looking at the old one, that's why I'm on the wrong side. Sorry, case 2506-0012. Thank you.
A second.
All in favor?
Aye.
Aye.
As I said before, sir, you do have the opportunity to come and ask for a reduction. Okay?
Appreciate it. You guys have a good day.
Now we're going to case 5. Okay, thank you.
Evening board, council, Andrew Snodgrass, City of Clermont.
Thank you. Evening again. Andrew Snodgrass, City of Clermont. Good evening, board. Good evening, council. We did move on to item number 5, yes. This is case C2410-0015. It's for 3262 Hanging Tide. It's for City Ordinance Section 125-522, building permit required. The courtesy notice was given out on October 15th. I did a verbal courtesy notice on October 15th when I spoke with the owner and his son at the property. Paper courtesy notice was provided whenever they came into the office the following week and requested an extension. I went ahead and provided the courtesy notice with the extension on the courtesy notice. Violation was sent out on December 30th, 2024. The owner requested a variance due to the property not meeting setbacks and some other things. The variance hearing was held on April 8th, 2025. A hearing notice was sent out June 12th, 2025. That was returned. So July 7th, the hearing notice and the notice of violation were posted. And as of today, there are no applications for permits in the system. This is the courtesy notice. The notice of violation. Yes. Move on to the notice of violation.
Okay.
The notice of hearing. This is the order of denial for their variance application. Application date was February 12th. The hearing was held on April 8th. It's the affidavit of posting for the notice of violation and the hearing notice. The location of the property via Lake County Property Appraiser. So this is the building plans for the original. As you can see, I'll highlight here on this. As you can see in this area here is the backyard. There is no patio. There's a covered lanai, but there is no patio. This is a picture from the online listing. It's a nice aerial view, so I went ahead and snapped it from Zillow. All these pavers are additions, minus the driveway. The gazebo that was added on. It's 3'6" from the property line, so it does not meet the required setback, which is one of the issues for the variance request. As you can see in this picture, it comes almost directly to the property line. Comparison on the left was 2023 from a prior case. On the right is 2025. You can see the additions. So there's pavers, lighting, patio, electric, and the gazebo that were all added without any permits. This is underneath the gazebo. As you can see, there's electrical with the junction box, the fan. Additional electrical on the right-hand side there. More electrical right there on the gazebo.
Is this electrical operable?
Pardon me?
Is this electrical working? Is it connected?
Yes, it is.
Okay.
Just quick case summary, October 15th, complaint received. October 22nd was the requested extension. November 5th, the HOA called regarding ongoing construction at the property. Whenever I spoke to the owners on October 15th, they had a gazebo there that was destroyed by the hurricane. That first gazebo was put up without a permit. When that gazebo was destroyed by the hurricane, it was removed. When I went back and spoke to them, they said they're going to put up another gazebo. Requested they get a permit before they put up the gazebo. Like I said, as of today, no permits have been applied for. December 30th, the notice of violation was sent out. January, the owner came in and requested another extension. I did provide them with a letter at that time, giving them another 30-day extension. February 12th, that extension was over, so they submitted a variance application. February 18th, they requested another extension. Due to the variance app, I advised the owner that the case was on hold until the variance was completed. March 13th, the property was listed for sale. April 8th, the owner came in for the variance, paid for the variance and came in, and the variance was denied at the evening council meeting. May 9th, email from the HOA stating that the owner was having a fence built, and the HOA stopped them from building that because a permit is required for that as well. Since then, no contact has been made, property's been posted. So staff's recommendation is to find the respondent in violation of the section stated and to assess a fine of $150 per day for every day the property remains in violation after September 20th, 2025. I don't have anything further. If you have any questions, their respondent is here as well.
Chair, do you mind if I ask the city a question before we hear from the respondent?
Sure.
So the variance application, was that for the setbacks?
Yes.
So what, didn't have anything to do with building without pulling a permit? It was just for the setbacks?
Correct.
Okay, thank you.
So sidewalks are on that setback as well of 33 feet?
I believe the only thing that was on the variance was the rear property setback. The
patio.
yes,
Concrete patio.
yes, it goes almost to the property line, and there's
Right.
there's a required setback it did not meet.
So there was never a variance given for that, or?
No, it was not approved.
That's for the, that patio, that concrete patio?
Yes,
Okay.
and for the sidewalk also, but in the variance it specifically stated the gazebo in the rear setback, not the side yards.
Okay, so the, those pavers on the side for the walk,
They do not meet setback either. They would require a variance as well.
Mainly just that corner piece that we saw, that
Yes,
section there. Gotcha.
yes.
And then just for clarification, you had mentioned that there was a gazebo there prior, destroyed during hurricane, and they have since built another gazebo
The gazebo that's in the pictures is the one that is currently there
there
and
now.
was built
Okay,
afterwards.
thank you for
yes.
clarifying.
Yes.
Did you mention that the previous gazebo had a permit?
Previous gazebo did not have a permit.
Okay. Is there something you'd like to tell us?
If you would, please state your name and address for the record.
My name is Luis Corona. I don't speak English, but my friend can
Is he going to translate for you?
for me.
Okay, if you're going to translate for him, could you please raise your right hand? Do you swear or affirm to translate accurately for the record? Thank you, sir.
Ok, la otra vez que vinimos me pidieron los permisos, en los lugares en los que estoy trabajando. Lo que sé es que se está dando la asociación para que la asociación no nos permita y creo que ya debe estar ya listo. O sea, que la asociación no se meta y no puede.
First of all, I'm sorry for that happens. I don't know anything about that, right? So the thing is, I just bought the gazebo in Amazon. Why build it? I just want the concrete in the back. I just build by myself. First of all, because they sell it in Amazon too, right? So, oh, paper. Okay, I'm sorry, paper. So the problem is, you know, I had the problem in here for fixing. I had a new blueprint, the new size making ones, you know, the back by 10. You say 10, right? It's,
For
the
the-
legal thing is 10.
10 feet for the setback? Yes.
I'm working
I
with
believe
that.
so.
That's what they tell me. Because, you know, I find a company to engineer guys to do this rate. So that's very much what I have. But I just bring these papers to submit to the association and the HOA and the city of Clermont. For that.
So a question for the respondent would be, is his position that he needs time to come into compliance? Well, first, ask him that. Is he asking for time to come into compliance?
Cuando salimos de la reunión de acá, que hablamos con la asociación, me dijo que eso no me dio tiempo, me dijo que sometiéramos los permisos con ellos para que nos aprobaran, pero no me dio tiempo.
So they don't give me any time when they do the, when I spoke to the HOA. So the only thing is, he take his time for find the right company to build the right ways that are gonna problem in the future.
Is his intent to reduce the size of the patio and sidewalks to come into compliance with the setbacks? Okay. It's up to you if you want to submit them, but if those are originals, they have to keep them. If you want them to introduce them, they can consider it, but he's got to leave them.
No problem, I can give you a copy.
Okay. Do you all want to receive them?
I am not currently interested in receiving them. I'm assuming that those are going to have your, it's the site plan that's going to show where your sidewalks are for setbacks, and then would also show your impervious surface, which impervious surface is hard surface. So you can only have, it's less than 50% of your property can be hard surface. So with him having that giant patio with a gazebo, the pavers all the way around, there's some math involved in determining those things when he goes in for permit for the for the pavers and his gazebo, that should then require the engineered drawings for the gazebo.
You like to decrease down? I'm not sure. It's 10 by 8. The back, yeah, right?
Well, that's setback.
System, yes.
The setback, yeah, everything has to be 10 feet off of the property line
What I have in here.
for for the structure.
Yes.
You will have to check on sidewalks, those may be different for property line.
Sidewalk, yeah, that makes different. Below the sidewalk.
And that's why he will more than likely need to hire an architect or something along those lines to do the drawings, because the architect is going to know code setbacks, everything that needs to be, and then that would be your site plan that gets submitted to the city, that they then save on file forever, assuming nothing changes on the property.
They have to move complete.
Yeah.
The house, 3 feet down, and move 10 feet. They have to move the complete, with the size too. They have to move down.
Yeah, that's something when you deal with the architect, that they will determine where the patio and gazebo would sit on the property, so that you're not within the setback area, which constitutes a violation.
Andrew, can I ask a question, just to help me out? In order for this property to come into compliance, they need a permit first, because they don't have a permit for any of the work. And then the work that has been done has to be basically redone to meet setbacks and all the guidelines, impervious land, setbacks from property lines. So it's multiple issues to come into compliance.
Correct. As stated, there are 0 applications for a permit as of today. When that application comes in, it'll be reviewed. You may need engineer plans, architect plans. Not sure what exactly would be required. That's more for building services. But the process is that when you get a building permit, they'll review it and they'll ensure that you meet all the setbacks. Once that is issued, then the property would have to meet those plans that were issued, which may be removing some of the pavers, maybe removing retaining wall. Not sure exactly what it would entail. The permit would state all that.
So I have a question for the respondent. Why has he not applied for a permit? It's been 6 months, at least.
He has coming after, whether he's coming the first time a year or what? Before installation or after?
Well, the first gazebo had no installation, but we're on today. So today, there was no permit for the gazebo, no permit for the electrical, no permit for the pavers, and the variance for the setback was denied. So,
The first time when he's come over here, they asking for the gazebo, not for the pavers and the electricity, you know. But now, it's more different things. So I have to speak to the contractor now, the engineer, for, be like more specific about the electricity and everything, but to submit everything now.
The respondent doesn't contest the fact that he has not applied for a permit for any of these things, right?
It's That's why he's here for everything what he needs for do everything by right place, by right.
So one of the things the board can consider is how much time to give give the respondent time to come into compliance, like whether it's 30 days or whatever. How much time does the respondent want the board to consider?
¿Cuánto tiempo tú necesitas?
Ya todos están más o menos en la resolución y la primera resolución no la aprueba. Y después inmediatamente.
Okay.
So real quick, before you answer that, you see that up there? So right now, we're saying 60 days.
So that's the city's recommendation, 60 days.
A mí nunca me han dicho que quite el asilo, sino que someta el permiso. Me han dicho, para quitar el asilo necesitamos un permiso de demolición. O sea, es complejo. Cuando a mí me toca la primera vez, no podía quitar el asilo porque necesitamos un permiso de demolición. No tiene manera. Y para quitar el permiso de demolición queremos pedir el permiso para removerlo. O sea, es complejo.
He says he not do anything before because he had to find out a company for demolition to the gazebo. So now he find the right company for do everything together at one time. So how much time he need more for fix the thing? That's what they do.
Right. How much time would he like the board to consider?
¿Cuánto tiempo necesitas tú para
Si yo someto la permiso hoy en mañana y ellos me la aprueban, no sé cuánto tiempo tardan cuando después me la aprueban, en una semana lo tengo listo todo.
Okay. So he says you submit this paper to the HOA and the city of Clermont, and after that he go for after he get a permit. Because
Okay.
we want to make this finish like right away.
The question the member asked, and that I've asked twice and hasn't been answered, how much time does he want the board to consider? So what happens is if they find him in violation, they give him time to come into compliance. The city is requesting 60 days. If he's not in compliance in 60 days, and that's the board's order, he will accrue fines of $150 per day for each day the violation remains out of compliance. So how much time would he like the board to consider? A specific number of days. If he doesn't want to provide a specific number of days, that's fine. I just wanted to give you the opportunity to give a specific number of days for them to consider.
And this is time to to have the building permit in his hand, not work completed. So how long will it take for that to go through the HOA, you think, and get an architect engineer to have your drawings for the gazebo and then submit it to the city of Clermont for your permit? That's the question.
He said 30 more days. I said, well, he got everything to there, the paper submit and everything.
Can you put the, thank you. So would September 20th be enough time for him to get the permits?
The only thing is, everything is fine, the only thing is submit and that's it.
I'm sorry, I couldn't hear you.
Oh, he said he got everything in hand, the only thing I have to submit to the city and the HOA. And that's, and then after that, we fix everything together at least 1 month. He said
Okay.
September 20th.
I understand he's in the HOA, but our concern is with the city, not with the HOA. So we have nothing to do with the HOA. What we need are the permits, so you can submit it to the code enforcement. You put fill out the application, submit the permit, and then once you'll be able to become in compliance and work with the code enforcement, and they will be able to help you. So you're happy with September 20th? Okay, thank you. Does anyone else have any questions? No? Can I get a motion, please?
I'll make a motion. This is number 5.
Yes, sir.
Based on the testimony and evidence presented in case number C2410-0015, I move to find that the respondent, as listed in the notice of violation, moved to find that respondent is in violation of the City of Clermont's Code of Ordinance as listed in the notice of violation filed in this matter. That I have considered, 1, the gravity of the violation, 2, any actions by the violator to correct the violation, and 3, any previous violations by the violator. I move to order that the respondent correct the violation on or before September 20th, 2025. In order correct the violation, the respondent shall take the remedial action as set forth in the notice of violation, or if different, list the specific remedial actions to be taken. If the respondent does not comply with the order, a fine of $150 amount will be imposed each day the violation continues past September 20th, 2025. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Do I have a second?
I'll second.
All in favor?
Aye.
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 Aye. You have to September 20th. You're welcome.
Are we moving to case number 8?
Yes, this will be item 8. This is case C2502-0006, 550 Distant Avenue. This is for a violation of Section 1853, subsection 6 and 10, Section 1854, IPMC 303.1. The notice of violation had other violations on it. They were corrected throughout the course of this case. The violation notice was sent out February 5th, 2025. Certified and regular mail were returned. Property was posted on February 18th, 2025. And a hearing notice was sent out on May 5th, 2025. It was sent to a different address, and it was received. This is the notice of violation. The top 2 violations on there, 304.13 and 302.7, have been corrected. The
Which
rest,
one was those?
pardon me?
Could you repeat that, please?
Yes, ma'am. 304.13 and 302.7. The top 2 violations on the
Okay.
notice of violation have been corrected. It's the affidavit of posting for the notice of violation. This is the notice of hearing and the USPS receipt for the notice of hearing being delivered. This is the location of the property, the Lake County property appraiser. posting on the property in February. This is the property as of February 4th. The state of the pool as of February 4th and the fence. The broken window by the front door, that was part of the first 2 violations that were corrected. The state of the property throughout the case, this is all February 18th, 2025. This is in April 2025. We received a complaint from sanitation for dumping on the side of the property for large bulk pickup. That was removed in the end of May, I believe. This is the state of the pool currently, or this is in April, I'm sorry. May 20th, state of the pool. As you can see, the fence and the debris were still there on the side of the property. The grass is starting to get overgrown. State of the pool on May 5th, state of the pool on June 19th. This is the state of the property as of today. There is a dumpster that has been there for approximately 2 weeks, but also showing the front yard, the state of the front yard. So February 4th, a complaint was received regarding the property being abandoned, large hole in the front glass by the door, fence panels falling over, grass overgrown, a pool that is green. In March, I spoke with the owner. Window and grass violations were resolved. Fence panels and tree debris were placed along the right-of-way. A door hanger was left by sanitation. April 3rd, spoke with the owner regarding the debris bulk pickup. He stated he would contact sanitation that day. It was June 2nd before the debris was finally removed from the property. The grass was cut. Pool is still in violation. As of today, no progress shown on the property. The property is extremely overgrown. The overgrowth is not a violation that was listed on the notice of violation, so I'm not addressing that as of today. We'll be addressing that as of tomorrow. The staff recommendation is to find the respondent in violations of sections stated, 1853, 1854, and IPMC 303.1, and to assess a fine of $150 per day for every day the property remains in violation after August 20th, 2025.
Any questions?
Nothing further. I don't believe a respondent is here.
I do have one. Is the city seeking a health and safety tag?
No.
I'll make the motion. Based on the testimony and evidence presented in case CBC 2502-0006, I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before August 20, 2025. In order to correct the violation, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $150 will be imposed for each day the violation continues past August 20th, 2025. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Second.
All in favor?
Aye.
Aye.
Andrew, I have a question regarding that pool.
Yes.
That's also a health department violation there, isn't it?
It would be a health department violation, yes.
And they can take immediate action with that, can't they?
Yes, sir, they can.
Okay, thank you.
Yes, sir. The structure of the pool, the screen, everything else is solid, so not a health, safety, welfare issue for us, but for health department, yes. And to follow up on a question that you had before this meeting, there was an issue with, or a question about the previous case having a winter garden address. Just wanted to follow up with that. There is a subdivision in Clermont that is called Lakeview Preserve. all of the properties in there have a Winter Garden address, but they are inside of Clermont city limits.
Any other cases?
That's it. Motion to adjourn?
Yeah, if there are no other cases, any other business from the city?
No other cases.
We have a motion.
Second?
All in favor?
Aye.
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 Thank you, Board.
Can I make sure that I have the, let's see, 2025. So September 15th and November 17th? Make sure I got those in my calendar.
Okay.
Well, but if I don't enter it now, I'll listen.
Patrick, can I ask you an adjacent question?
If you can, if you turn off your microphone and come over here, so.